Welcome to Under the Basswood Tree with Basswood Counsel, a podcast where we bring you brief, valuable conversations and insights to help you navigate the complex world of business transactions. From cross-border deals to international tax structuring, we cover topics across all industries. Our team and colleagues will share their insights and provide practical tips on key issues for you and your business. Let's get started.
Hello, welcome back to Under the Basswood Tree. I'm your host for today, Renee, and today we'll be talking about one of the most common questions in estate planning. Should your estate plan be centered around a will or a trust? To help us unpack the details, we are joined by one of the partners at Basswood Counsel, Chris Klook.
Thank you, Renee, and thank you for everyone for joining. Basswood Counsel, Basswood Tax, built for what's next. I'm always happy to demystify estate planning, and especially one that of the basic kind of centerpieces of estate plan, whether it's a will or a trust. Happy to be speaking on this topic.
All right, let's start from the top. We hear a lot about wills, a lot about trusts, but we sometimes don't know which one do we actually need. So, big picture, how do you frame the will versus trust conversation?
Well, what I do is I try to educate the client. Both wills and revocable living trusts play a big role in estate planning, but they function differently. And will is kind of what you're used to in the movies. Someone dies and they pull out the will, who's been disinherited. That's kind of the basic estate planning document people are aware of. But a revocable living trust is a more comprehensive strategy. It covers more situations, and it allows you to avoid the court system at someone's death while achieving the kind of same goals that a will would accomplish as far as distribution of assets, perhaps creating trust. Is better for incapacity planning, for maintaining privacy, and to manage assets efficiently. But it's important for clients or whoever may be doing an estate plan to understand the differences so that they can make an informed decision.
So there are a lot of kind of trusts out there. What exactly is type are we discussing today?
We're discussing a fully funded revocable living trust, and that's key. Revocable trusts that we're talking about must be funded. If there's nothing inside the trust, you have not avoided probate. So it's very important that it's coordinated to get the advantages of a revocable trust. This type of trust is where a person creating it, known as the grantor of the trust, also serves as a trustee, and during their lifetime, they're the main beneficiary. This means they keep full control over the property while they're alive, and they also can change the terms, revocable trust. They can change the terms of the trust as family circumstances may change. And then upon their death, a successor trustee steps in, or when the grantor becomes incapacitated. And this allows for more continuity of the estate plan where you don't need to go to a court to intervene.
So if someone comes to you, say, hey, Chris, I want to create a trust, what are the steps?
Well, there's a few steps. First, you're going to have a conversation with the client. A good estate planning attorney would have a conversation with the client about their goals. Well, why is it you want a trust? Why a revocable trust? How do you want to leave assets to your children? Are there any charities that you want to give assets to? So you would do a kind of a comprehensive estate planning strategy with them to begin with, and you're going to learn about the client because it should be customized. It shouldn't be a fill-in-the-blank exercise. Plenty of attorneys, or you could go online and do fill-in-the-blank forms. One example we experienced, someone did a revocable trust, one of those document drafting softwares that you're probably aware of. And what they did is they drafted a pour-over will that pours any assets outside the trust into the trust. What they didn't draft was a trust. So this will poured into nothing, and then there was no estate plan. So having a very customized approach, these are assets that this grantor, this person is worth their whole life to develop, create. And so this is kind of, this is what they created for their family. And so it should be something that's very customized on how it transitions through. Customized to what the person, the grantor. Once we have that established, then we move on to drafting the trust document. Again, from the information we learned from that conversation, we now know how to customize the trust document. What should distributions be during incapacity? They're married. How should assets be held when the first spouse dies? What happens when both spouses dies, or if they're single, who receives the assets after that? Should the assets be held in trust? What are the different ways assets can be held in trust? If they are held in trust, should be distributed outright at a certain age, or should they just be distributed outright to the beneficiaries? And there's a lot of circumstances to think through, both the person creating the trust, but you may also, if you have a child that's really, really, really wealthy, you may want to leave them the assets in a certain way to not increase an estate tax exposure they might have. So there's lots of planning that goes back and forth, and it's important to customize that into the trust document. You can also, put into that document, and this can go for a will too after the death that trust created, that I want to leave them money to start a business if they have a sound business plan in the trustee's mind. So there's lots of customization. And then after you get the trust document signed, then you go on to funding the trust. So I previously discussed how important funding the trust is. And so we coordinate with clients the funding of their trust, because that trust has no value. The revocable living trust has no value if there's nothing in it. You're right back into the court system, probate upon someone's death. So funding the trust, we can't do it for the client, but we can follow up with them, make sure they understand how to fill out forms, help them deed the property in, their real estate into the trust. And now with that, I've been with a few estate planning firms. One was fully on board where we followed up with clients, made sure they funded their trust, and we have a system. And then I've been at other firms where they leave it to the client. They send them a 30-page document explaining how to title assets into the trust, and that never works very well. So our approach is very much to work with the client to fund the trust, because that's how important it is.
So when I hear, I need to put an asset in a trust, so the asset is no longer in my name, a lot of people worry that they would lose control of these assets. Is that true?
That is not true. And I think a good example is symbolically, you would transfer through a deed of transfer your personal property into the trust, and kind of get a laugh. But as soon as you transfer your couch into the trust, you can no longer sit on it unless your trustee gives you permission, right? So with this fully funded revocable living trust, the grantor, the person that created the trust, keeps complete control over the assets, can take assets in and out of the trust. You should leave them in, by the way. There's no new income tax filing. It's filed with the personal, any income generated on trust assets is filed with the personal 1040 of the individual. And you still get homeowner benefits such as the exclusion from capital gains on the sale of your personal residence. So very much you're treated as still owning the assets for most legal and especially for tax purposes. A revocable living trust is disregarded as a separate entity for purposes of tax.
So I can still sit on the couch.
You can still sit on that couch. You can still sleep in your bed.
Well, that sounds great. All right, you mentioned a little bit about probate, and let's talk about it. Let's start with the misconception. People think having a will avoids probate.
No, having a will does not avoid probate. In fact, a will has no effect until it's been submitted to the court. So the will has no power. It has to be submitted to and accepted by the court after someone's death. So a will only works through probate, and probate means to prove the will and is a court process. So why can a revocable trust be beneficial as compared to a will? It depends on circumstances. Some people may want court oversight. So having a will with the court overseeing the administration could be a benefit. They're not so concerned about the time that might be involved, the costs. But usually probating a will and the administration through a court system, the fees can often cost 2 to 5% of the estate. So it's costly, time consuming. It can take as little maybe as 6 months or up to 2 years or decades. It could take a long time. Just depends on the circumstances. Are there contests? Are people really contesting everything? The will itself is public. So someone could go check the court filings and see the will, see who's receiving assets. There's also an inventory of assets that has to be listed, listing the assets of the decedent, the person who died. And so that becomes public record. A fully funded revocable living trust avoids that because the trust owns the property, successor trustee steps in. Anything held in the trust does not need to go through the probate system. So that preserves privacy, and typically it can be a more smooth process and less costly.
So is probate expensive?
Probate can be expensive. I mean, it's going to depend on how complicated the estate is, the assets involved. But, for example, even if the probate fees equal 2% of a $500,000 estate, that's $10,000 in fees. You're going to have executor fees, you're going to have legal fees, probably accounting fees. Some of this you would have of a revocable trust as well. But having to go through a court system, they become more streamlined, but it's going to add costs and time. And so it can be significantly less expensive to have a trust that avoids all that.
So in a trust, what happens if someone becomes incapacitated?
So if someone becomes incapacitated, here we're talking about really the grantor and beneficiary of the revocable trust. Since they're trustee, the successor trustee would step in for that grantor, and then they would manage the assets. A good trust document will provide how to manage the trust and pay for expenses during a grantor's incapacity. And so that's beneficial as compared to perhaps there's nothing in place, so whoever's going to take control of the assets and manage it for the benefit of that person has to get a conservatorship in court, meaning someone to manage the property. So that's a process. A lot of families can fight about who should control the assets. People like control, I guess. And so that can create inter-family conflict. Now, you could have a financial power of attorney, which could avoid the need for the court proceeding. But the trust is more fully integrated with instructions on how to manage. And so avoiding that court proceeding and court involvement of management of assets and distributions or payment of expenses during that grantor's incapacities can be a great benefit.
So I would say it'll be more of a streamlined process if there is a trust in place.
Absolutely.
So are trusts better for creditor protection or taxes?
Depends on the type of trust. So we're talking about a fully funded revocable living trust. And this type of trust doesn't provide any creditor protection. But that's not really the goal of the trust. There's a few goals, but incapacity planning and avoiding the probate and more of a comprehensive plan, to name a few. So there's no creditor protection and it doesn't save you any in taxes. The types of trusts that are creditor protected and save in taxes or can maybe save in taxes are irrevocable trusts. And when I say taxes, we're meaning estate gift, generation skipping transfer tax, perhaps income tax, depending on the planning. But those types of planning a lot of times require the grantor to gift away the assets into the trust where they're no longer the beneficiary. And that makes sense in a lot of situations. It just depends on the circumstances. But that's not what we're talking about with this type of trust. This type of trust is fully revocable. And so then if the grantor can take the property back and is indeed the beneficiary, creditors can get at those assets. But it can, in a certain extent, provide some protection when that person dies or if they become incapacitated, because you don't go to the court system to submit a will or a conservatorship proceeding where those proceedings invite interested heirs in so now you created the court proceeding, they can contest things. The revocable living trust, someone would have to probably pay an attorney and then file the paperwork to create the court proceeding. That's going to be more cost than being invited into the court. So in that sense, the revocable living trust provides a little bit protection to your estate plan because someone's going to have to think long and hard whether they want to pay money to start a proceeding that in most cases they're likely to lose.
Sounds like wills versus trusts. Wills are less private and trusts offers more privacy. And also trusts are harder to contest. So when is a will enough and when is a trust a better option? Like how does one weigh these two circumstances?
So at the end of the day, it's personal. And what you need to do is provide the client with the facts they need or the circumstances, and you learn their goals to pick what's best. But in general, and we have a handout on this, younger people tend to choose wills because it doesn't cost as much at the beginning. Older people who are thinking more about death will think more about the transition of property, and that favors trust. If you have no children, a will, it can be much easier. If you have children, trust can make sense. If your estate is small, that favors a will over a trust typically. If you're not concerned about incapacity, that would favor a will plan over a revocable trust. And if privacy isn't important, that would favor a will over a revocable trust. And so we take a step back. Estate planning in itself, estate planning is more than documents. And estate planning evolves with time. And so just because you create a plan when you're young, you're like, all right, I just want a will now. It doesn't mean that your estate plan should not evolve as you get older and maybe now have kids or your wealth has increased or you have property in multiple states and move to a revocable trust plan. And so, just like with businesses, they update their operating agreements from time to time. An estate plan should be updated with changed circumstances. Who should be the fiduciaries, trustees, executors, power of attorneys? If you created a plan when your children were very young, maybe you made your parents as the guardians if you were to die. But now that the kids are in their teens and your parents are old and maybe can't stay up with them, or they live somewhere else and ripping your kids out of the community they are in might be traumatic, you may have a different idea who should be the guardians of your children. So thinking of estate planning as evolving over time is important as well in viewing of what documents you should have today and where you're going in the future.
So would it be right to say your estate planning grows with you?
Absolutely. It's something you should be thinking about. And estate planning, depending on your circumstances, kind of incorporates everything. It's your life. So if you're, as part of estate planning, you should consider either if you're an employee and you make X amount of dollars, if you were to die, that's out of your family's wealth. How do you plan for that? What should be in place? If you own a business, that should wrap in, the estate plan should wrap in not just wills and trusts, income tax planning, business succession planning. How does this all tie together? And so as your circumstance changes, you need to relook at your estate plan. And ideally, you can coordinate everything together to make sure everything's covered.
So what if, let's say, a family feels there might be a lot of conflict in the event the parents pass away? Would a will be actually better?
It depends on the type of conflict. But if you think court supervision would be beneficial, because if you had your children maybe all chosen to be executors, in this situation, it'd probably be wise to have a corporate executor. But if you think one might try to steal money or take from the estate and take more than they deserve, you may want a court to supervise that. And so that's one aspect of why a will might be better depending on family circumstances and if there's conflict. But remember, if you want your estate plan to stay in place, if you have everything in a trust and you have mechanisms to take care of conflict, maybe an arbitration clause that they have to go to arbitration, costly. And again, by having it in a trust, you don't invite them to the court. And so by, on the other end, maybe some of the conflict can be avoided by not inviting them to the courthouse. That proceeding that's unnecessary and probably frivolous never gets started.
So having a trust doesn't necessarily mean there is no supervision at all.
That is correct. Either the trustee could bring in action in court through the trust. They could get aid and direction from the court on what they should do. Beneficiary could seek court intervention for various reasons. It just means that you don't have to go through the court system if everything's in the trust.
Well, that has been very helpful. So the takeaways seem clear. Both wills and trusts, they have their place, but a revocable living trust offers major advantages, especially around probate, incapacity, privacy, and making things easier for loved ones.
Yes, exactly. The best choice depends on the individual circumstances in the family. You want to think through everything. You want to have a comprehensive plan. And most importantly, it's important that in developing your estate plan, you understand the difference between a revocable trust plan and a will plan.
Well, thank you so much for joining us today. And to you who are listening, if you enjoyed this episode, remember to subscribe, leave a review, or share it with someone who might need some help in navigating their estate planning decisions. Until next time, plan smart, live well. Thank you.
We hope you enjoyed this episode. To stay up to date with the latest legal insights and Basswood events, please follow us on our Basswood Counsel LinkedIn page and visit our website at www.basswoodcounsel.com. Thanks for tuning in, and we'll speak to you next time.